what it is.
Further hearing the Commissioners for Majesty's Revenue and Customs against investment trust companies.
Mr. Vinovitz.
My Lords, at the end of yesterday, I had been making my submission that following the decision of this court in Menelaw, the correctness of which is not in fact challenged by the Commissioners, it is now established that the approach of English law is to reject the idea that there is a bright line requirement that would mean an indirect payer can never claim that an enrichment was at his expense for the purposes of a claim in unjust enrichment. And again, that following Menelaw, it is clear that there can be exceptions to the direct providers rule. And indeed, that in this context, English law will not shut its eyes to the commercial and economic reality of the position, to the substance of the position. And in my submission, that is all clear following Menelaw. And I had also submitted that having regard to the commercial and economic reality of the VAT system as it applies in this jurisdiction, and the role in that system of the consumer on whom the tax is in fact imposed and paid to the Commissioners, the payment of VAT by a consumer, which is received by the Commissioners, is or should be regarded as an exception to any direct providers rule, for the reasons given by Mr. Justice Henderson at paragraph 72 of his judgment. And I taken your Lordships to the passages in Elida Gibbs. Your Lordships will recall that was at paragraph 49 of Mr. Justice Henderson's judgment, where the Court of Justice had explained in relation to VAT, and your Lordships will have in mind this is an EU law tax,
Yes.
EU tax, that the basic principle of the VAT system is that VAT, which is of course a tax on consumption, is intended to tax only the final consumer, and that it was not in fact the taxable persons who themselves bear the burden of VAT, and indeed that the sole requirement imposed on the taxable persons is in effect to collect the tax on behalf of the tax authorities and account for it to them. And I'd also shown your Lordships a passage from my Lord Newberger's judgment in University of Sussex at first instance, which, putting a gloss on Elida Gibbs, noted again that the function of the taxpayer in this system is simply to act effectively as a tax collector for the Commissioners. And at the end of the day, I had referred your Lordships to the decision of this court in Harvey. I was not proposing to take your Lordships back to that. Your Lordships may recall that in that judgment, my Lord Newberger again cites the passages in Elida Gibbs to which I've taken you with approval. For your Lordships notes, Harvey's at volume 4, tab 47, page 1862. The relevant passages are paragraphs 19 and 20, page 1869. And my Lords, against that backdrop, I'd made the point that one strong indication of the fact that the role of the taxpayer is simply to collect the tax on behalf of the Commissioners from the end consumer is provided by the bad debt provisions of the VAT Act, section 36. And I wonder if I can just show that to your Lordships. I don't think you've been taken to it. It's at volume 1, tab 7, page 453.
Thank you.
Page 453.
Yes. Bad debts. Yeah.
Bad debts, and your Lordship sees paragraph 1 says subsection 2 below applies where a person has supplied goods or services and has accounted for and paid VAT on the supply. The whole or any part of the consideration for the supply has been written off in his accounts as a bad debt, and a period of 6 months beginning with the date of supply has elapsed. And then 2, subject to the following provisions of this section and to regulations under it, the person shall be entitled on making a claim to the Commissioners to a refund of the amount of VAT chargeable by reference to the outstanding amount. So anything which isn't paid, he's entitled to claim back. And in my submission, my Lords, this shows just how strong the connection is between the payment by the consumer and the enrichment of the Commissioners. And it illustrates the fact that the taxpayer's role in these arrangements is really simply to act as a collector of tax, and that it is the consumer and only the consumer who is intended to bear, and who does bear, the burden and pay the tax. And that is why we respectfully submit that both the judge at first instance and indeed the Court of Appeal were correct to conclude that even allowing for a direct providers rule, the present case fell within an exception to the rule, because even if the payment was indirect, it was nonetheless clear as a matter of reality or as substance that the enrichment of the commissioners by the £100 was at the expense of the ITCs. And perhaps just one further point to note in this context, my lords. Your lordships will recall that yesterday my learned friend took you to the Court of Justice decisions in Riemsma and Danfoss. And those decisions make it clear that in the context of the VAT system, the end consumer is given a San Giorgio right. And in my respectful submission, that is a very significant point. Because, as your lordships know, San Giorgio is a case which establishes that where a state has unlawfully exacted tax from a taxpayer, that taxpayer has a right, a European right, and it's a very strong right, subject only to one defence, which is the passing on defence, which again reflects the position of the consumer in this. The taxpayer has a right to a refund. Now, the relevance of Danfoss and Riemsma is the recognition that the consumer here has the right. The end consumer has the right. In terms of how that right is enforced, it might be enforced through a route which involves claims by the manager, but that shouldn't distract your lordships from the point that what the Court of Justice is clear about, and this is common ground, is that the end consumer has a San Giorgio right. And what, in my respectful submission, that indicates is that as a matter of European law, and after all, we're talking about that which is a European tax, as a matter of European law recognizes that the enrichment of the commissioners is at the expense of, in every real sense, and certainly in a legal sense, I can put it that way, the end consumer. And in my respectful submission, my lords, it would be extremely odd if that recognition by European law of this European tax was not also reflected in English law. Perhaps I can put that point again. If you are recognizing the existence of a San Giorgio right in the hands of the end consumer in relation to VAT, what you are recognizing is that the tax, as they say in these cases, that he bears the burden of the tax, and it is his tax burden which is enriching the commissioners.
Are you content that the limits under common law should be the same as the limits under EU law?
Am I content that the limit should be? With respect, my lord, that is not a submission I'm making. All I'm doing is to use.
No, I'm just wondering. I mean, your primary case is that the common law is as wide as it could be. If there are limits to San Giorgio, do you accept that they? And if you're arguing backwards from EU law, as you are at the moment, do you accept that the limits ought to be carried through or back into common law?
For the purposes of this claim, I could accept that. I don't see why they need be that wide. But accepting that here doesn't hurt my position at all, and we'll get on to limitations.
No, because we're arguing about EU law ultimately.
We're going to argue about EU law. At the moment, we're just arguing about European law. But English law. But what we're doing is arguing about how you regard the substance of the position in relation to payment of VAT, which is a European tax.
Yes.
So to that extent, you cannot divorce European law from the analysis. And the only point I'm making, and I'll repeat it once more, move on, is perhaps I won't repeat it. Given the recognition in these cases of a San Giorgio right, which is a reflection of the fact that this is a tax borne by the consumer, and therefore it's the consumer who should have a right of repayment, in my respectful submission, that is a recognition of the close connection, if you like, between the consumer and the payment of the tax, and indeed the enrichment of the state, and that it would be very odd if European law recognises that, if English law didn't. And of course, your lordship will recall that Woolwich, thinking about how the common law is constructed and how it develops, in the context of Woolwich, St. Georgia was pretty critical in Lord Gough's analysis as to why Woolwich should be developed in the way that it was, so as to allow a claim for unlawfully exacted tax. And in a sense, I'm using that as an analogue here. If you can use European law position to say, well, wouldn't it be odd in the Woolwich context for English law not to recognise a claim here, I say exactly the same thing applies in this context as well. Now, my lords, insofar as it is necessary for the purposes of the English law of unjust enrichment, which is what we're still talking about, to bring this into the context and a construct of transfer of value, in my respectful submission, I have no difficulty with that at all. And again, as EU law on this shows, and indeed as Riemsma and Danfoss shows, there is indeed here a transfer of value from the end consumer to the commissioners via the VAT being collected by the taxpayer. Now, it is, with respect, no different from what happens in Menelaus, where you are dealing with discrete transactions, where this court stood back, and it's not, as I say, challenged. The correctness of that is not challenged by my learned friends. This court stood back and says, in effect, you're dealing with a single transfer of value. In my respectful submission, supported by European law, I say precisely the same analysis can apply here.
While you've moved on slightly, I've been thinking about the point you were last making, and it just occurs to me that while obviously we're concerned with the common law, the San Giorgio entitlement has to be transposed into the domestic legal systems of all the other member states as well, which for the most part will be applying civilian concepts of restitution. And there'll be some variety or other of Roman condictiones, I imagine. And I suppose the difficulty that one sees in Riemsma and Danfoss, which gives rise to the proceedings in Luxembourg, it presumably results from Dutch law and Italian law envisaging a remedy on the basis of absence of basis as between the parties to a transaction rather than the consumer having a right of recovery under Dutch law or Italian law directly against the state as a tax collector, as a taxing authority. And I suppose then the point of Riemsma and Danfoss is to say that, well, albeit that's a situation under your domestic law of restitution, at the end of the day, if there's an obstacle such as insolvency that prevents recovery by the consumer, then your domestic law has to accommodate that. I don't know about Italian or Dutch law, but I imagine that there must be some background of that kind.
There must be some, but with respect, whatever the law is there, we do have the law of unjust enrichment, which does allow claims against the state and indeed the commissioners, and DMG is clear on that, and indeed FII is clear on it. We've had any number of authorities which accepts that, and indeed they accept that in the context of San Giorgio. So the only question here is, in circumstances where we're dealing with VAT and there is a San Giorgio right, is there any reason at all why English law, just as it has in these other areas of the law of unjust enrichment, should not recognize the European position, i.e. that you have a San Giorgio right? And I'm not, at this stage, I'm not saying this for the purpose of saying, at this stage, I'm asserting my San Giorgio right. What I'm saying is there is a San Giorgio right there. I'll get onto that in due course. That reflects the relationship between the payment by the consumer and the receipt by the retailer. We will come on to the European point, I hope before the end of today, certainly intend to, and your Lordship will see that one of the points, the European point is quite a short one, because in the end, Malone does not dispute that there is a San Giorgio right. He doesn't dispute that the doctrine of effectiveness applies. He doesn't dispute that if that means that it's virtually impossible or exceedingly difficult to get a remedy, we're entitled to a claim against the state. I don't dispute that that remedy can be provided by a claim by the manager against the state. The question is whether that provides me with an effective remedy. And we will get to that. It's, as I say, it's not a short point, but it's easy to understand. At least the question is easy to understand. At this stage, however, if I can just focus more on the law of unjust enrichment. Can I perhaps just address a point? I think my Lord Hodge yesterday made a point about whether we'd looked at foreign cases.
Yes.
And the reality is, at first instance, we did, and we didn't find anything that was going to help. And we included, as I think I've suggested, any number of academic articles, including some which were comparative law articles. The reason I come back to that at this stage is that here, if you want to look at the most relevant comparator law in terms of recognizing whether there is a sufficient nexus between the payment by the consumer and the enrichment of the revenue, then in my respectful submission, one goes to European law, because it's both a comparator and indeed informs our system. And if European law recognises the nexus, then in my respectful submission, there's no proper basis upon which English law shouldn't. Now, I think I said yesterday that the position that the Court of Appeal, and indeed Mr. Justice Henderson reached on this point, is one that finds general support by all the main academic writers. And we've given references to that at paragraphs 36 and 37 of our written case. That, for your references, is page 189, Court tab 10. I wasn't going to take you through those references. What I was going to do, however, is to take you to Professor Virgo's article, because, of course, Professor Virgo is the most prominent opponent of any exceptions to the direct providers rule. And as I shall show your lordship, Professor Virgo regards the decision in ITC as being correct. He still maintains there should be a direct providers rule, but he accepts that there should be some exceptions, and he regards the facts of ITC as appropriately giving rise to an exception. He calls it exceptional facts, but he recognizes. This is not the view, as I think I indicated yesterday, that he has about Menelau. I think he described it as the worst decision ever handed down by a House of Lords, but that's between Professor Virgo and your lordships in relation to that. But so far as ITC is concerned, Professor Virgo's view is that the conclusion of the lower courts here is correct. And can I just invite your lordships to look at that? You'll find that at volume 5, tab 61, beginning at page 2637. Tab 61, page 2637.
Yep.
Sorry, where have we gone? We've gone to?
Page 2637. It's in, if your lordship's in the hard copies, volume 5, tab 61. Page 2636 is the cover. 2637 is where he deals the chapter on at the expense of the client. And your lordships will see from this extract that the starting position for Professor Virgo, which one finds set out between pages 2638 and 2640, continues to be that the general rule in English law is or should be that only direct payers or direct providers have a claim in unjust enrichment. However, from page 2640 onwards, under the heading B, indirect enrichment, your lordships see that Professor Virgo acknowledges that where, having regard to the economic reality of the position, page 2640 towards the top of the page, he says that having regard to the economic reality of the position, it can be said that the enrichment was at the expense of the claimant, then even an indirect payer should have a claim in unjust enrichment. And if I can invite your lordship...
Sorry, which page? I can't... Which
page 2640.
Where on that page?
So the requirement of direct connection between the and defendants
Yes.
has however been qualified. Some of these qualifications are clear exceptions to the direct enrichment principle, but others, when analysed carefully, do not qualify that principle but are consistent with it. One then has the heading economic reality, where
Yes.
Professor Virgo analyses it. And just picking it, and your lordships can see towards the bottom of the page, in fact, he says, just picking about 8 lines from the bottom, although the courts have retained the general principle of direct enrichment, they are starting to acknowledge that even an indirect enrichment can be considered to be at the claimant's expense, but something more than but-for causation needs to be established to show that B's actions have not breached the chain of causation, which requires focus on the economic reality of the case. This test is clearly influenced by the decision of the House of Lords in Banque Financière and Park, because even though it was held that the defendant company was directly enriched at the expense of the claimant, the court reached that conclusion specifically with reference to the realities of the case. The significance of examining the economic realities of the case was identified in the very important decision of investment trust companies, this case. The Court of Appeal affirmed the decision of Mr. Justice Henderson, who had recognised that although there is no rule which automatically excludes unjust enrichment claims against indirect recipients, there is a general requirement of direct connection to which there are limited exceptions. In determining these exceptions, the following principles were identified. And then Your Lordship sees he sets out the exceptions and refers to the facts of investment trust. But if I can just pick it up at the bottom of page 2641, where he analyzes the ITC decision, he says, this is an important decision which undoubtedly modifies the strict requirement of there being a direct connection between the claimant's loss and the defendant's gain, although that principle is still affirmed as the norm. The exceptions to it are founded on the need to establish a connection between the claimant's loss and the defendant's gain with reference to the economic realities of the transactions, even though a strict causal connection cannot be established. This was recognized by the Court of Appeal, which noted that the supplier's duty to account for the VAT operated regardless of whether the VAT was contractually due as between the customers and suppliers. On the facts of the investment trust company's case, the recognition that the tax authority was enriched at the expense of the customers appears correct, because the tax authority, he says, had undoubtedly been unjustly enriched at the direct expense of the suppliers, but for a technical statutory reason, the suppliers could not obtain full restitution. By recognizing an exceptional principle of indirect connection, the customer's claim for restitution of tax were not avoided on a technicality, especially because the tax authority should not have received the tax in the first place, and restitution was required by EU law. And then he goes on to say, I hope this isn't the thin edge of the end of a wedge, and so it transpires in his view. He's not very happy with Menelau.
Not very happy.
No.
Sorry?
He's not happy with Menelau, my lord. He's not happy with this being used generally to widen the scope of...
But we're back to exceptional facts, which is never helpful. And we're back on his case to exceptional facts, which is always a useless test. And then economic reality.
Indeed. Well, my lord, if the test is that you should have... I think where Professor Virgo would probably go, your lordship is right, where he goes is to say there should be a direct providers test, but if you're looking at the economic reality or the substance of the position, this is in fact a payment which is moving from the end consumer to the defendant, then you come within at the expense of requirement.
So we're back to economic reality.
I think we're back with economic reality. Your lordship will recall that the other approach may be to say what we're really doing is looking for transfers as per what restitution is about. But again, I have no difficulty with that, because in my respect for submission, it may be that one has to look at the reality of the position, and I don't apologize for using that word. I don't think English law should shy away from looking at reality. Where you look at the reality here, there is in fact a transfer, as recognized by EU law, from the consumer to the commissioners through the body of the tax collectors, who is the taxpayer here. Which seems to be Dr. Wilmot Smith's position.
Yes, I see. Thank you.
So, my lord, and I can tell your lordship just briefly without taking your lordships to it, Professor Mitchell, who is the editor of Goff and Jones, has written an article about ITC where he says the decision is right. And we also know that Professor Burrows, in his restatement work, cites the VAT context as an exception to the direct providers rule, without any suggestion that he thinks that should not be the law at all. As I say, all the main writers, my lord, support.
So this is where Professor Burrows cites it?
He cites VAT, a payment of VAT by an end consumer
yes, he took us to that. In the restatement.
In the
I
restatement.
was going to say, in the restatement,
Tab
yes.
58, yep.
And he does so without any suggestion that he thinks that this is wrong or a...
Are there statements in the restatement where he does doubt propositions?
They are, my lord.
Yes.
But 2597 is where he refers to test claimants, yep. Tab 58, yep. Okay.
So that's what we say the position is. Now, what do my learned friends say about this? My learned friends make two objections to, in a sense, the approach that the Court of Appeal has taken. They say first that a test that focuses on the substance or the reality, economic or commercial, is fuzzy, I think is the word they use, and they pick that up from Lord Justice Moses' position. Whether that's any fuzzier than duty of care and the kind of open-textured approach that one has to take in the common law when you're dealing with different facts in different cases and you're trying to grow it incrementally? I don't know. But the second point they make is to say that even if you are going to focus on the substance and on the reality, what you shouldn't be able to do is use that as a substitute for a but-for causation test. I recall my learned friend saying yesterday that uniquely, he says, in ITC, the court used the fact that in substance this was a transfer from the consumer to the commissioners as a substitute for a but-for test. And my lords, in our respectful submission, and just for your lordship's notes, they say this between paragraphs 19 and 21 of their case. I wasn't inviting you to turn it up, but it is at page 140.
Thank you.
And my lords, we say there is nothing of substance in either of these points, and we would submit that as the first of the points, there is, with respect, nothing difficult at all. Certainly in the context of this case, in looking at the substance rather than the form, any more than there was in Menelaus in looking at the substance rather than the form and the reality. I'm sure there'll be cases in which that might be difficult, but neither this court in Menelaus had no difficulty at all identifying the reality of the position or the substance of the position. And in our respectful submission, here too, there is no difficulty. Indeed, can I make this point, my lords? My learned friends do not even challenge the fact that as a matter of substance, it is the consumers, the ITCs, who bore the expense that enriched, who bore the payments, who bore the burden of the payments that enriched. They accept that. They don't dispute it because they, with respect, cannot dispute it. But despite that, they say that if you look at the substance, this fuzzy test gets you into trouble. Well, there may be cases in which it is different. But in this case, in circumstances where there is no dispute at all, that the reality of the matter is that the enrichment of the defendants was at the expense, in any real sense, of the claimants, there is no difficulty in applying that test at all. And in my respectful submission, my lord, that may be an open textured test, but that is often how the common law has to develop, because the problem with trying to identify sharp rules, bright rules, is you very soon encounter an exception to that rule, which proves that the rule doesn't work. And we know this from our experience of duty of care and trying to ANZ in London Borough of Merton and the like. One has to have something open textures so as to enable the court to consider the facts and to say, well, as a matter of reality, at whose expense was the defendant enriched?
But does that in practice become a but-for test then?
A but-for. With respect, no. In a sense, it's a substitute for a but-for test. If you, I think I accepted yesterday, and indeed have accepted all the way up, that simply applying a but-for test with not looking for any greater connection is going to open the net too wide. And I think Dr. Wilmot-Smith makes a good point about that.
Well, the TfL case would be rightly decided on that basis.
Although, to be fair to the Court of Appeal, and it's not really my job to be fair to the Court of Appeal, they can be fair to themselves, that was a strikeout. And all they were saying is this is a developing area of law. We need to get to the facts. It is wrong to stop this at this stage. Now, the facts there are startling, and I can see.
Well, as Lord Mance says, there is the fact that the actual beneficiary was a party at one point to the proceeding.
And I see that. But I don't have to defend the button
No.
because that isn't my position.
No, I see.
But I think what I do need to do is to deal with my learned friend's suggestion that even if I satisfy your lordships that as a matter of reality, as a matter of substance, the defendants were enriched at the expense of the ITCs, I should not have a claim if I can't get through the but-for test. And my answer to that is to say that that is completely misconceived. The purpose of looking at the substance is to decide whether the enrichment is at the expense of the defendants. If you apply that test and you conclude, having regard to the substance, the reality of the matter, that the enrichment of the defendant is indeed at the expense of the claimant, then with respect, there is no need, there is no necessity to apply a but-for test. You've answered the question you wanted to ask, namely that the connection between the payment by the claimant and the enrichment of the defendant is sufficiently close to regard the defendant's, that payment as being at the expense, the defendant's
Yes.
enrichment as being at the expense of the claimant.
It seems to me an answer to my question. The but-for test would be wider. One can construct a set of facts where the but-for test would be satisfied, but you wouldn't say in substance.
Well, in fact, in this case, I say it's satisfied.
Yes, I know. But
in the same way as it was satisfied in
it's a more generous test.
It's a more generous test.
That's the point I'm making.
And I think what I'm saying, with respect, I'm sorry, I didn't understand your lordship.
No, I put it badly.
But it is a more generous test, and effectively I'm saying if I can satisfy the narrow test of a sufficiently close nexus, a nexus which is so close that the court says that in substance and in reality the enrichment was at the expense of the claimant, then with respect to the but-for test is OTS.
It's not exactly necessarily wider. I mean, in some situations, I think you accept but-for could be narrower than substance test, because you say substance test displaces the but-for test.
Quite difficult to think of circumstances where it would be. Yeah. But anyway,
one way of testing this is, it all depends on what one means by but-for, if I can answer the question that way.
Or in substance.
Or in substance.
Yes.
And indeed, Menelaus was just such a case. And I refer to that because if it is the case that I have to satisfy the but-for test, I satisfy it in exactly the same way that the claimant did in Menelaus. Your lordships will recall, in fact, it was my Lord Newburger's judgment, where my Lord put the test on the basis that the charges were released, on the basis that, I think is the language your lordship used, my Lord Newburger used, on the basis that they would get a charge over the new property. Now here, the tax was paid by the taxpayer to the commissioners on the basis that there would be a payment of the VAT by the consumer to them. And we know that it's on the basis that because Section 36 says if there isn't a payment, you can get it back. But, so my Lord...
Well, can I just ask you about that? We agreed yesterday that in an indirect benefit case of a present kind, there are two successive transfers of value, and you have to demonstrate that each of those transfers is defective because it's affected by some unjust factor.
Yes, but they're not unrelated transfers.
No. I take that, but just just testing it. If the second transfer had not been defective, on another set of facts, you pay me a deposit to do work on your house, and that contract falls through for some reason or other. But in the meantime, I have given the money to charity, for example.
In fact, we can take the facts of this case. We can
all right, we'll take the facts of this case.
Let's assume the manager doesn't make an election to rely upon European law. Mm-hmm. Don't want to get too far back in this because it's complicated and I'll have to deal with it later. But we know from cases like, is it VDP and also NDDP, that the manager can elect to say, look, you have messed up, UK. You have not properly implemented the 6th directive. But you know what? I don't mind applying. I don't mind UK law applying to me. So I'm going to regard myself as bound by UK law. You have a situation there in which the consumer is paying a VAT, because he's the one who has to bear it, which is undue. But as between the taxpayer and the commissioners, the taxpayer is saying, I'm happy to be bound by this. So one, you have a defective transaction, defective transfer, and the other, you have a non-defective transfer.
What happens if the taxpayer collects the money from the, receives payment for his supplies, inclusive of VAT, from the consumer, and he then uses the money to pay his corporation tax bill?
With respect, my Lord, he can use, I'm not saying I can trace the money. I certainly don't go that far. What I am saying is that whatever the money is, whatever the amount is that he's collected from me, is what he is collecting from me to transfer. Now, he can transfer it from a different account. He can do what he likes with the money he's collected from me. But the money that he has collected from me as VAT, that sum of money has to be paid on as VAT. And it's in that sense that there is a transfer of value in a broader sense, in a Menelaus.
Does he owe you a duty to pay that money?
No, I don't think he does it.
Whereas in Menelaus, on the basis that, which you concentrate on, was involved a legal duty to do that.
But he owes the commissioners a duty to pay on the money.
Yeah, but not the person who paid him.
Well, with respect, I'm not sure why that should make a difference to whether or not you regard this as a transfer of value from the consumer to the commissioner.
Because you're looking at the connection between, if you've got A, B and C, you're looking at the nature of the connection between A and B and the connection between B and C.
Yeah.
If you treat the taxpayer as B, then C, who pays the money, hasn't got a right to say how that money is going to be dealt with. In Menelaus, I think it was different.
With respect, you may not have a right,
Quite.
but there is an obligation on the taxpayer to deal with the money in that way.
Yeah, but no obligation owed to the person who pays it. If you're linking him in.
I accept that. I accept that. But as I say, we do know that if you look at the VAT system as a whole, the whole structure of the VAT system is to cause a transfer from the consumer
Yes.
to the commissioners.
Well, in the sense that the consumer pays a sum of money to the taxpayer then has to conduct his affairs with HMRC in accordance with the relevant law, but that doesn't necessarily involve making any payment or payment of any particular amount to the revenue.
With respect, it does require him to account for that amount.
Either
Maybe
through
that he
payment or
paid-
set off.
Indeed. So he has to account. So it's undoubtedly the case that the revenue is enriched by the amount that we pay.
So,
now, they may not
but
receive that.
are you saying then that if the entire amount was set off, there would still be a restitutionary
Absolutely.
claim against the revenue?
With respect, and that is common ground, because the reason it is set off is to discharge a debt which is payable from the revenue to the taxpayer.
But a debt which doesn't exist on a proper understanding of the law.
No, your lordship, in a sense, with respect, is going from testing to see what is the nature of VAT generally to, in a sense, the facts of this case, which we'll come to, which is what is the consequence of an election which you make, which in a sense involves you being able to say, I don't want to be bound by English law. And with respect, if we're going to test the position as a matter of English law, the nature of that as a payment and whether there's a transfer, in my respectful submission, it simply confuses things at this stage to talk about, well, what happens if I, in a sense, have to disapply the earlier law?
Well, don't you have to? Because the whole basis of the unjust enrichment claim is that under EU law, no tax was payable. And you're not permitting the revenue to say in reply, well, we didn't receive anything. Because under...
We'll come to that, my lord. But with respect, when you're asking about the nature of the payment that the consumer in a VAT context makes to the commissioners, in my respectful submission, it is much easier to see what is happening if you don't, since bring in the facts that we're going to have to look at under the last issue, which I have to deal with before I sit down, which is what is the extent of the enrichment.
That's a different point.
It's a different point. It does, in my respectful submission, serve to confuse rather than to clarify the nature of VAT and the payment in this context.
I was wondering if... I mean, this isn't... the point I'm pursuing isn't one that's necessarily against you. I'm trying to get beyond these rather vague ideas about economic reality and the like. I'm just wondering if perhaps it might be fruitful to think of the nexus which would justify a claim based on indirect enrichment in terms of successive defective transfers where there is some sort of nexus between the defect in each case.
Well, in this case, there plainly is, my lord. In this case,
That's why I'm saying it's not necessarily a point made against you.
I understand.
What I'm wondering is it a fruitful way of analysing the problem?
Well, it may be, my lord. And if it is, then in my respectful submission, it assists me. Because in this particular case, undoubtedly, the defect between, in a sense, the two stages of the transfer, the stage between the person paying the tax to the tax collector and the tax collector passing it on, that which makes it unjust is exactly the same in each case. There's a mistake made as to whether or not whether or not English law complies with the European directive, so that the manager had a choice not to charge that tax.
All right, and when you come to the set-off bit,
Yep.
there's a mistake there, and the tax collectors, you called them, or the managers here, have benefited by the mistake, by being able to set off what they wouldn't otherwise have been able to, which might be 100%.
Well, that may be so. And then the question arises, at whose expense has that happened? In my respectful submission, we will get to that. It's issue 4,
Yeah, that's
not issue now. It's issue 4. In my respectful
I
submission,
understand
the answer to that is clear. It's at the revenues expense.
No, well, that's issue 4.
But I don't want to get into that because
Right.
I have a long way to go before I
It's
get
a separate point. I accept that. That's point 4. Yes, I see. And you say if there needs to be a connection tying in the initial payer to the intermediate recipient, it may be weaker in this case than in Menelaus in the sense that there's no legal obligation on the linking the payer, initial payer to the initial payee, in the sense that the payee isn't obliged to deal to the payer to deal with the money in a certain way or the asset in a certain way. The link is sufficiently close in light of the analysis in Elida Gibbs.
Indeed. And with respect, I'm not sure I'd accept that it's a weaker link in circumstances where this is the whole structure of the VAT system.
Well,
There are
that's what I'm saying,
obligations to
Elida
collect,
Gibbs, all
indeed.
right.
Yeah. Indeed, I apologize.
All right, you're right, all right. You say that the link is at least as strong as Menelaus because of the Elida Gibbs type
Exactly.
analysis.
It's
Okay.
inherent in the system. I apologize. That's
No,
really picking the
I
points.
put it in a slightly loaded way. That's your point.
So that's what we say about the first of the 3 grounds that Malone and Friends have advanced in this context for saying that your lordship should not recognise that the enrichment of the revenue was at the expense of the ITCs. They say this may be the test, but even if Mr. Justice Henderson was right, as the Supreme Court in Menelaus said he was, that there's a directed provided rule subject to exception, we don't fall within the exception number 1, in the sense that there isn't a sufficient causal connection or sufficient connection. In my respectful submission, that is not right, for all the reasons I've given. There are 2 other grounds that I need to deal with before I get to section 87. The second of the grounds is the suggestion, again picking up on the indicia that Mr. Justice Henderson identified to universal acclaim, which is that one has to have an eye out for multiple exposure. And your lordships will recall, I think it's paragraph 67 of his judgment, that this was the second of his points. So I just want to just open and have a look. So tab 12.6, paragraph 67. Your lordships have at page 327, in fact paragraph 68.
Which page?
327, it's paragraph 68.
Oh, yes.
So we've dealt with the first one, the need for a close causal connection. The second point that the revenue take relates to the second one, the need to avoid any risk of double recovery. And they say that this is also something which is of concern in the present case. But what is interesting, my lords, about the point they make here is they do not suggest for a single moment that there is any risk of double recovery in this case. So this is, in a sense, floated out there almost as a policy ground, but it has no application whatever to the facts of this case. Because Mr. Justice Henderson found, this was in paragraph 69 or 70, that there was no risk of double recovery, and there's no challenge to that at all. So it is simply floated out there, I think, as a policy consideration. Now, I'm not for a moment saying that your lordship should not have in mind that kind of consideration when deciding how English law should develop. But what Mr. Justice Henderson had in mind is something completely different to the point that my learned friends advanced, because he had in mind, in any particular case, look to see if there's a risk of double recovery. But there isn't in this case. The point seems to be a different one, and this is a point that your lordships may recall they make at paragraphs 22 to 26 of their written case. They seem to say that if you allow claims in unjust enrichment where the end consumer might be allowed a claim against the commissioners, this may result in effect, this is one of the examples, in lots of claims being brought against the commissioners. And they give the example of a situation in which the VAT is passed down to 2 or 3 chains, if you like, of consumers, so that the end consumer at the end, who's bearing all the tax, is multiplied. But with respect, my lords, the fact that there may be a number of people at whose expense the commissioners are enriched, the fact that the commissioners are enriched at the expense of a number of people is not only a reason why this claim in this case should not be refused. In my respectful submission, even in that situation, that in itself is not a reason why the claim should not succeed. The fact that the commissioners have unlawfully enriched themselves, they can't use as a defence we've done so at the expense of a lot of different people, and therefore none of you should have that claim. In my respectful submission, that is legally incoherent. Now, it may be that that is terribly inconvenient for the commissioners. And if it is, then of course, as the commissioners have shown themselves ready to do on numerous occasions in this area, they can legislate, as they have done repeatedly, to prevent that claim happening. But certainly, absent legislation to prevent that claim, if there are a number of consumers who are at whose expense the commissioners are enriched, then in my respectful submission, the fact that there are many consumers is not a reason why they shouldn't have a claim. The second example that they give, and this is going to bring us back, unfortunately, to the manager who elects to be bound, to the taxpayer who elects to be bound by English law, which they take from the VDP case, is a situation in which, and again goes back to my Lord Reed's example, or perhaps my Lord Mance's example. You have a taxpayer who, in the UK, there is English legislation which does not fit with the 6th directive. We're going to come to it, but as my learned friend showed you yesterday, it's common ground that the taxpayer has an election. The taxpayer can elect to continue to be bound by English law, notwithstanding that it is out of sync with EU. He can say it suits.
We've had that with a large number of times.
Well, this is his example, not mine, and he brings it up here. And the only thing I can say about it, I don't want to dwell on it, is this is not an issue for the law of unjust enrichment. It is an issue which arises because the English legislature has not brought its legislation into line with EU law. And although it gives rise to an anomalous situation whereby, as my Lord Reed Burns points out, you might have the revenue worse off by a certain amount of money, that with respect is not at the expense of, if I can put it away, that is not, if the revenue are enriched, are worse off.
Unjustly impoverished.
Unjustly impoverished. Yeah. I'm not sure it's unjust because it's their own fault,
exactly.
If I can put it that way.
That's what I thought you'd say.
But in any event, that's not because they haven't had accounted to them the full amount that the consumer has paid. They have. What has happened there is that the middleman, the collector, claims an input VAT as a result of a different transaction that he has.
Well, wait a minute. Are we on point 4 now? Are we allowed to go into this?
We're not even close, I'm afraid.
Right.
There's not point 4 at all now.
We're not there yet.
On your approach, is the revenue and unjustly enriched at the expense of both the taxpayer and the consumer? And the consumer. I mean, you've been trying to persuade us that it's unjustly enriched at the expense of the consumer. Section 80 and so on proceeds on the basis that revenue is unjustly enriched at the expense of the taxpayer, which presumably must be right.
Well, except that your Lordship will recall Section 80, subsection 3, which basically says, in the context of the statute, which is intended to repay overpaid amounts, that it is a defence for the revenue to say that you would be unjustly enriched if we paid the money to you. In other words, the statute reflects the fact that as a matter of reality, someone else is likely to have borne that expense. So in fact, with respect, the statute does not proceed on the basis that the the revenue will be, necessarily be at least, unjustly enriched at the expense of the taxpayer.
So you avoid incoherence and double recovery by saying that the taxpayer has no claim in unjust enrichment.
Indeed, the taxpayer, in fact, has no claim because of Section 80, subsection 3. And that reflects...
or at common law.
Or at common law, indeed. Or indeed, I should say, at European law as well, because we will come to this. But I've mentioned the San Giorgio right, which is a very strict, very strong right of recovery. The one exception to that is passing on. And passing on in this context is not the same as passing off. Passing on means you have passed the burden of the tax onto someone else. In other words, it exactly envisages the kind of situation that we're dealing with.
Can you just remind us where we find that in St Giorgio?
St Giorgio, your Lordship will find in Volume 2, at tab 12. And if your Lordships go to page 680, you'll find paragraph 13. This is a point that is made in a number of cases. That
Which page? I do beg your
Volume 2, tab 12, page 680, San Giorgio.
Oh, yes. Thank you. Sorry. Yep.
Yes, paragraph 13. Yeah.
13. However, it says, as the court has also recognised in previous decisions, in particular the aforesaid judgment in Just, community law does not prevent a national legal system from disallowing the repayment of charges which have been unduly levied, where to do so would entail unjust enrichment of the recipients. There is nothing in community law, therefore, to prevent courts from taking account under their national law of the fact that the unduly levied charges have been incorporated in the price of goods and thus passed on to consumers. Thus, national legislative provisions which prevent the reimbursement of taxes, charges, and duties levied in breach of community law cannot be regarded as contrary to community law, where it is established that the person required to pay such charges has actually passed them on to other persons. And that is what lies behind Section 80, subsection 3. You, the taxpayer, have passed on the burden of this tax to the consumer. To give you the money would unjustly enrich you. You would have something you're not entitled to.
And you say it supports your view that the customer must be able to claim, otherwise there's a reverse hole.
Indeed. And what we have, when we get to Danfoss, is exactly that.
Yes, I see.
In Danfoss, we will see that.
Yes, thank you.
But I thought in Reemster and Danfoss it was accepted that as a general rule, schemes under which the taxpayer could recover money were acceptable.
Were acceptable, indeed. And I don't I obviously accept that. We'll get there at issue 3, but Danfoss effectively in Reemster says the consumer has a San Giorgio right. It's up to the member state to decide how to, in a sense, give you the remedy for that San Giorgio right. It's okay if what you have is a scheme which involves the money going back to the manager without the consumer having a claim against, provided it's effective to ensure that the consumer is repaid. And in this case, it's accepted that the consumer wasn't repaid. But I'll come to that.
But the point is that I think in Danfoss, they said that if the recipient, the consumer, would have been able to recover the tax invoice to it in error, then in that situation, the taxpayer, the manager, will have a right against the revenue. So that, I mean, in a sense, it's circular. It's chicken and egg, depends where you start. If, in this case, you view the consumer as having had a right for 3 years at least to recover from the manager, then that may shape your view of what is unjust enrichment and what the law of unjust enrichment, at least in EU terms, ought to be.
We'll come to that. That's issue 3. But with respect, in my respectful submission, there's no proper basis upon which you would say that the consumer has a right for 3 years to recover. There is no... We'll have to look at who the rights and obligations apply to. But in my respectful submission, to suggest that the consumer has a right to recover as a matter of law within 3 years simply ignores the relevant statutory provisions and the limitation periods and who they apply to.
Wait a minute. You mean, say, if I pay VAT to someone who's defrauding me by issuing a VAT invoice, or who's making a mistake by issuing a VAT invoice when it's not due, you mean I can't turn around and say to him, you've got to repay that?
With respect, of course you can. What I'm talking about, my lord, is the limitation periods.
It's a claim against the commissioners.
It's a claim against the commissioners. What I'm talking
Well,
about
I'm
is
saying it'd be a claim against the taxpayer.
Well, whoever the claim is against The issue, what in a sense I was not accepting from your lordship, is the application of a particular limitation period of 3 years to a claim by the consumer against anyone.
Okay, so I'm sorry, maybe it would be a longer period, but...
It would be a longer period,
six years,
and we will
whatever.
get to that,
Yeah.
but there isn't that kind of limitation.
Yes, very well.
So I think I've dealt with everything I wanted to say about multiple
Double
claims.
recovery, yeah.
Multiple claims. The third and final point that Malone and Friends make in this context is the leapfrogging point. Now,
Yes.
again, if your lordships noted Malone and Friends' written case, the way this point was put, this is at page 144, tab 9,
Yeah,
was on the basis of a statutory leapfrogging.
yes.
The argument was that what is happening here is that you, the consumers, are trying to jump out of a relevantly applicable statute, and that is a consideration which falls within the paragraph 68 Mr. Justice Henderson analysis as to indicate that you need to look out for before you allow an indirect provider's claim. That argument was with respect hopeless, but has now been abandoned.
Right.
It was hopeless because in a sense it turns on the issue that we have to come to next, which is the application of section 86,
Quite.
paragraph 7.
It's circular.
It's circular.
Yeah.
We either are bound by a statute which prevents us claiming, or we're not. If we're not, but that argument has been abandoned. Instead, what we had from a learned friend in about 5 seconds is a reference by him to Professor Burke's book about contractual legal.
Yes.
Now, that, as I say, is not the case that's been put in
No,
in
we've
the
got
written
that.
argument. But in any event, if your lordships look at what is said in the written argument, I'm not inviting you to go there. The way they put it in the written argument, with respect correctly, is that if you can find some inconsistency arising as a result of the contract, you can't leapfrog out of that inconsistency. Now, Mr. Justice Henderson found that there was no inconsistency. Malone and Friends never appealed against that or said that was wrong. And indeed, they can't identify any inconsistency here relating to the contractual obligations that we have accepted as compared to the claim that we now want to make. So I'm not going to say any more about that because, as I say, it's not the case that they were running in their written case, and in any event, it is misconceived. Can I then move on?
The implications of this are quite important. You're following it, you're really saying that a Woolwich claim doesn't apply to VAT. Taxpayers don't have a Woolwich claim if VAT is unlawfully levied.
Well, they may if they are, in fact, unjustly, if the revenue is unjustly enriched at their expense. But in circumstances where they do not, in a sense, we know that they don't, because Section 80 prevents them having it.
Yeah.
So
But even at common law, I mean, assuming the VAT is operated the way it's supposed to, and they are collecting VAT, they're collecting VAT in inverted commas from their consumers, they can't have a Woolwich claim.
Well, if we forget about Section 87 and say, would they have had one but for Section 87? Well, they might if they haven't passed it on. But if they have passed it on, then one could quite see the court saying, in what sense have you been enriched? In fact, I'm not sure that that's right, actually, because my recollection is that in Kleinwood Benson and Birmingham, what the Court of Appeal rejected there was the idea that there's a passing on defence in English law. Now, that's Court of Appeal level, but and it's the only court that's actually looked at it. In other words, someone tried to argue that just as in EU law, you should look to the further arrangement and say, you've passed it on, you haven't been unjustly enriched. In the Court of Appeal it wasn't Kleinwood Benson, the Kleinwood Benson against Birmingham, the Court of Appeal, and I think we have that in the bundles, the Court of Appeal said we do not have that passing on defence in English law. So that defence wouldn't work well.
Thank you.
No, but if VAT if VAT requires the taxpayer to account one way or another for VAT which is collected, and in the event of a failure of collection because of bad debts, relief is given, then effectively, leaving aside the possibility of exceptional cases, in the general run of cases, there cannot be a Woolwich claim made by a taxpayer in relation to VAT.
Well, subject to this point about passing on, because if it is the law of this, if it is English law, as the Court of Appeal said in Klein Lord Benson, that we don't have a passing on defence, then there can be such a claim. Of course, if the revenue has paid out, subject to anything else from your lordships, that was all I was going to say about issue 1.
Right.
Can I move on to issue 2?
Section 80.
Section 80. Now, just to put this into context, in other words, it's common ground that Section 80 is a provision added to the VAT Act in 1989 by way of Section 24 of the Finance Act 1984 as a result of, and indeed in response to, the decision of the House of Lords in a case called Commissioners Against Fine Arts Development.
Yep.
Now, that was a case involving a claim by the taxpayer against the commissioners in respect of overpaid VAT, in which the House of Lords rejected the commissioners' argument that they had a discretion in relation to whether to repay overpaid VAT. And the court and the House of Lords said that there was a right on the part of the taxpayer to get that money back. Now, just for your lordship's note, I wasn't planning to take you to it. Fine Arts is at volume 3, tab 33, page 1413.
Thank you.
What I might take your lordships to, because it's interesting, is the commentary on in the current law statutes annotated to Finance Act, which your lordships will have, volume 5, tab 64, page 2652, because what that shows is that Section 80 as a whole was a response to that decision. Page 2652.
I'm not sure where that goes. Yes.
So what one has at page 2652, the new section.
We've got the general note.
Your lordship sees the general note, and that makes clear that the object and purpose of section 24 to become section 80 was to put the right of the repayment on a new basis, that is to say a statutory basis, and obviously also to introduce a limitation period,
Yes.
and indeed the defence of passing on, because none of those existed under the position before section 80.
Okay.
And the point I'm trying to get out of looking at that statutory history is that the statute is directed at regulating claims made by the taxpayer against the commissioners in respect of overpayments. That is what the object of the statute was, and that is what in substance it does. And I'll take your lordships to it, but every section in that statute regulates the position of claims by the taxpayer against the commissioners. And the question that then arises, which is what separates the parties, is in the context of a statute intended to regulate claims by taxpayers against the commissioners, every one of which article, provision, deals with that. When you get to section 80, subparagraph 7, does that also apply in relation to the position as between taxpayers and the commissioners? Or does that have a wider import? Now, we'll look at the statute in a moment, but each of the judges below, when they looked at the statute, concluded that on the natural and ordinary meaning of the words used in section 87, the statute only regulated the position as between the taxpayers and the commissioners. Mr. Justice Henderson, at first instance, regarded it as appropriate to depart from what he regarded as the natural and ordinary meaning for what he called purposive considerations.
Yes.
We'll come to deal with that. But what is clear, as I say, is that each of the judges below thought that on the natural and ordinary meaning of the words, it did just regulate the position. Now, your lordships are plainly not bound by that, and I have to satisfy your lordships that that is, in fact, the position. Can I then invite your lordships to go again back to the statute? Your lordships have it.
Presumably, if we're looking at subsection 7 in that sort of context, we have to look at section 80 in its original form. Would that be right, as a matter of statutory construction, on the basis that unless, on the face of it, the addition of subsections 1A and 1B, for example, can't be said to or perhaps you say they do, change the meaning of section 80, subsection 7?
I'm not
You
saying
say it had this meaning from the inception.
that's its meaning from the inception. And I'm not saying that, and I'm not trying to argue that that isn't what the words say. I say the words are entirely consistent.
All I'm saying is that the addition of subsequent subsections is an irrelevance.
Well, it is irrelevant. Indeed, in fact, the only material amendment which has been made was made following your Lordship's decision in University of Sussex, which is when the word credit was added to the credit or repay. And originally, it just dealt with repayments. And the whole of the statute just dealt with, was predicated on the basis of repayments rather than credits.
Yes, I see.
Your Lordship said it didn't capture credits, and that led to an amendment following that case which captured credits. Now, I'm not saying that every single word is identical. I think section 87, subject to that addition, is identical.
Thank you.
I don't mind taking this either in the original or in section.
If you've prepared with the additions, I'm just...
Well, I was going to take you to the same...
528.
5, was it 528?
Is that right?
Oh, it was 533.
533, sorry, you did say that before, yep. Oh, that's right, it's 533, that's the relevant one.
And
That's 3 years instead of 4 years, so it doesn't matter, yep, okay. Yep,
now, I'm going to take your Lordships through this I think I could take your Lordships briefly through this because my learned friend took your Lordships.
Okay.
But the point I'm going to make in relation to each section is your Lordships are going to see the words credit and repay being used repeatedly. And they are used in the context of explaining a claim made by the person who has paid the money.
understand.
Every single occasion. So, section 80, subparagraph 1,
Has accounted.
has accounted, and your Lordship see the commissioners shall be liable to credit that person.
Yes.
So it applies again to the taxpayer. The taxpayer is the person who's accounted. It's to him that the credit will be given. It's 1A, where the commissioners have assessed a person to VAT, etc. They shall be liable to credit the person. So again, one has the taxpayer, and he's the person who is going to get the credit. You look at 1B. Again, a person has for a prescribed accounting period paid to the commissioners the amount of that was not due. Otherwise, then there is a result of certain things. Going to the last line, the commissioner shall be liable to repay that person. Your Lordships go to subparagraph 2, only liable to credit or repay an amount under this section on a claim being made for that purpose. Plainly, again, those words used in the context of dealing with the person who's made the payment, the overpayment, and not anyone else. 2A, where a claim as a result of under the section by virtue of subsection 1 or 1A above, an amount forced to be credited to a person, and again, that's going to be the person who made the payment. After setting any sums against it, some or all remain to be due to his credit, the commissioner shall be liable to pay or repay to him such amount. And again, it's dealing with the taxpayer. And I know I sound like a stuck record, but that's the structure of the section. When you get to subparagraph 3, it shall be a defence in relation to a claim under the section by virtue of 1 and 1A above, that's to say claims by the taxpayer, that the crediting of an amount, that would be a crediting to the taxpayer, and then it's about the unjust enrichment. An amount would fall to be credited under 1A above. The whole amount should be brought into account. I'm not sure I'm mumbling incoherently, ignore me. If your Lordships then go to subparagraph 4, shall not be liable on a claim under the section to credit an amount to a person under 1A, to repay an amount to a person under 1B. Again, it's the taxpayer who's being talked about in the context of the use of the word credit and repay. And then just jumping, I think, to 4A, there might have been other references, but 4A over the page 536. Where an amount has been credited, the amount so credited exceeded the amount the commissioner has made to the best of the judgment to assess the excess credit to that person and notify him. Again, used in the context of dealing with the claim by the person who has paid the amount. That is to say, the taxpayer on every occasion. And then we get subparagraph 7, which is the crucial system. Except as provided by this section, the commissioner shall not be liable to credit or repay any amount accounted for or paid to them by way of VAT that was not VAT due to them. And the short point that arises is where those words are used in subsection 7, are they used in the same sense that they are used throughout the statute? Because if they are, then they only apply to exclude the taxpayer from bringing claims outside the statute. They don't apply to everyone else who might conceivably at some point decide that they have a claim, rightly or wrongly. And in our respectful submission, there is no reason at all, there is no basis at all for assuming in a single section of a statute that the same words will carry a different meaning.
Well, if subsection 7 has the meaning as is said against you, then it will completely stop anyone making a claim.
Indeed.
It isn't just a time limit, it's an absolute bar.
It's an absolute bar, but let's just be clear, and I'll come to that. In a sense, one gets to the purpose of considerations that the judge took in mind. But what I'd like to, if I may do, is deal with it in the way that both the Court of Appeal and the learned judge did, which was to say, if I look at the natural and ordinary meaning of the words, where does that lead me? Then to say, are there purposive considerations? And I don't for a moment say that your lordship should not have regard to appropriate purposive considerations. Are there purposive considerations which leads me to say to a different result? Now that's where the Court of Appeal and the judge at first instance disagree.
It would help me to see section 80 in its original form, because the point I make is that I know there are conflicting authorities on this in some way, but the subsections that were added after section 80 was originally enacted are arguably inappropriate when one's construing section 80 subsection 7, because section 80 subsection 7 presumably hasn't changed its meaning as a result of the addition of other subsections.
Well, the only thing I would say about it is that it won't have the word credit in it.
Yeah.
No, it's not merely subsection 7, but it's the addition of the other subsections. That's what I'm getting at.
It's 518, isn't it? Isn't that the original form?
Well, the original one is at section 24 of the Finance Act,
420.
518, fine.
which is
420 tab 3.
It's 420, isn't it?
Well, that's the 1999 Act.
Yeah. That's probably the best place to look at it. Thank you.
420 tab.
Yes.
Yes.
And
I would
we
have
do the
thought that
same
would be the orthodox approach.
Yeah. Well, I'm grateful, my lord. So again, doing the same exercise.
Sorry, yes.
Where a person has paid an amount to commissioners which was not tax due to them, they shall be liable to repay the amount. Commissioners shall only be liable to repay an amount on the claim being made for this purpose. It shall be a defence under the section that repayment of an amount would unjustly enrich the claimant. No amount may be claimed under this section after the expiry of 6 years from the date on which it was paid. Where an amount has been paid to the commissioners by reason of a mistake, a claim for repayment of the amount under the section may be made at any time before the expiry of 6 years from the date of which the claimant discovered the mistake. The claim under this section shall be made in the same form and shall be supported by documentary evidence. I'm not sure that assists going over the page. Except as provided by this section, the Commissioner shall not be liable to repay an amount paid by that by way of value-added tax by virtue of the fact that it is not due to them. Preceding provisions of this section apply to an amount paid before as well as to an amount paid after the date on which the section comes into force. So again, one has this mapping, if I can put it that way, between the language which is used in the sections which give the claim and the language which is used in the sections which say that is the only claim you're going to have.
Can I just be clear on this? I mean, I understand your point about the context, but as a word of ordinary English, repay could, you accept that repay could refer to the payment of someone other than the person who paid it to you?
I absolutely accept that, and I've accepted it throughout. The question, however, in our respectful submission, is not whether this word can carry that meaning, but what was the meaning that the word was intended to carry in this context. And in my respectful submission, the Commissioner's position involves saying that the word, when used in subparagraph 7, carries a different meaning than the meaning it is used, that is given to it.
I mean, where one looks at it in section 1, it says repaid to him, so no doubt it's paid. Whereas in 7, the only limiting feature is that it should be money which has been paid by way of VAT and it was not due.
Well,
So, unlike 1, there's no limitation on the person who is paid.
Well, if your Lordship looks at subparagraph 2, shall only be liable to repay an amount under the section on a claim being made for the purpose. So again, that is not to him, but it's perfectly clear who they mean it is a repayment to. But it doesn't say so. In my respectful submission...
Well, that's limited by the claim, and then you have to see who can make the claim.
If one's looking at the original, subsection 5 is quite interesting, isn't it? Because do you say subsection 5, which doesn't limit it, in the original draft, in the original form?
Yes.
That isn't limited to the person who paid, is it, on the face of it?
claim for
Subsection
repayment.
5's come out, but that's how it was originally.
Why is subsection 1 limited to the taxpayer? I mean,
Because
your case is one should look at the economic reality.
Well,
and your
because-
case is that the economic reality is that your clients have paid the commissioner's VAT,
With respect
which
to the
wasn't
person,
you.
the person there is the taxpayer, and that's defined by the statute.
Well, I mean, all right, I see.
But what about subsection 5? Is
Well,
that
with
limited to
respect,
that?
subsection 5 says, when amount has been paid to the commissioners by reason of mistake, a claim for repayment of the amount under the section. So
Yes,
again,
quite right. Thank you.
It is limited to that section.
Yes.
So in my respectful submission, my lord, whether you look at the original or you look at the version now,
Well, can we just, again, you might say, if you're, some might say this is slightly over technical, but subsection 5 talks about the amount under this section. Doesn't talk about that in subsection 7, does it? Uses different language.
well, it doesn't use identical language, but
Well,
it's
it
talking
uses
about
much
liable
wi-
to
on
repay
one
an
view,
amount.
It uses much wider language that may be significant.
That would still require, my lord, the word repay being given a different and wider meaning than it has in the earlier sections.
Well, we've got to interpret the statute as ever speaking, haven't we?
And I'm very happy to do that. It may be ever speaking, but it's always speaking in the same words.
Yeah, well, I know, but I mean, it's speaking in a different context, and we now know that claims for mistake and so on are possible, and you say that unjust enrichment claims are possible. I suppose we knew that claims for mistake were possible when this was enacted, but unjust enrichment claims may be possible by third parties. Was it contemplated by this scheme that they could recover directly, or was this excluded by subsection 7 by implication?
And
On the basis that the scheme becomes really is really undermined to a considerable extent, isn't it?
Well, in a sense, the issue then, my lord, is this. Is what your lordship is doing a purpose of construction, a legitimate purpose of construction, in the sense that you say the revenue had in mind this sort of claim and it excluded it, or the language is so clear that whether or not they had this sort of claim in mind, the language is wide enough to exclude any sort of claim? Because in my respectful submission, that's plainly legitimate with respect to legitimate exercise. Or is what your lordship is suggesting one does here is what Lord Wilberforce warned against in the Royal Society of Nursing, which is to say you're plugging a gap, because the Parliament, which didn't have this sort of claim in mind, it was focusing on the taxpayer and claims by the taxpayer, didn't contemplate what to do with this sort of claim. And what one is actually saying is, well, if they'd thought about it, undoubtedly they would have blocked this.
Yeah.
And in my respectful submission, this is what the learned judge did, and this is with respect to criticism we make of the learned judge, as he embarked on precisely the exercise that Lord Wilberforce warned against in the Royal Society of Nursing, which is to say it is inconceivable that Parliament would not have done this, or would have wanted this. In fact, what is happening is he's plugging a gap. Because the words aren't wide enough, and there is nothing to suggest that Parliament had this sort of claim in mind. Indeed, everything suggests exactly the opposite. The words, the history, all suggest the opposite.
So is there on your case a time limit for recovery of this money?
Absolutely. It's section 32(1)(c). And that is a time limit imposed by statute. Well,
By the Limitation Act?
it's by the Limitation Act.
Yes, but under 32(1)(c) would, unlike under section 80, would absence of knowledge be a postponement of the time running?
Well, my lord, it wouldn't be, but your lordship looks at one sees the original version of this provision, where absence of knowledge did extend the period of time. And what has happened here is that because Parliament did not in fact have a claim of the sort in mind, and because the words that they used were not wide enough to cover this sort of claim, there is here a gap. Now, one could just say there is a gap, and therefore I'm entitled to take section 32. Well, what I say is there is a gap, and in those circumstances where my claim is not excluded by section 87, well, let's just be clear, I should step back. I don't have a claim within section 80. So it's not a question of, well, I would have had one there, but because it doesn't apply, I can have one somewhere else. I'm not in Section 80 at all.
No.
So it was never a limitation period that applied to me at all.
You say if you're within Section 80, then you're completely out of it because of subsection 7.
Absolutely.
But if you're never in it, then you are liable to normal rules.
If you are never in, you're liable to normal rules, because that's, sorry, let me put that slightly differently. The taxpayer is in, no question about it. He's in and he's given a claim. The quid pro quo for that is it's subject to a defence and there's a limitation period that applies. We are not in. We are not given a claim by this section. Well, I say we're not, well, I can say two things. We're not in the sense that we're not given a claim. The question is whether when Section 87 was enacted, the revenue had in mind people in our position and said they're not going to have any sort of claim at all. And in my respectful submission, as the Court of Appeal noted, if you look at the history, that doesn't seem to be right, and the words don't seem to be right.
Do I? Yes, and then we are on, you say the revenues on the horn is a dilemma, because if you are excluded by subsection 7, then you haven't got an effective remedy.
Then we get into the European point.
Yeah.
Well, I mean, obviously, Section 80, subsection 7, if it's construed against you, presumably has to be construed as subject to the San Giorgio principle, or is overridden by the San Giorgio principle.
Indeed. So the way it works is, if I have an unjust enrichment claim, if I'm right about issue 1, the only defence the revenue have to that is Section 87. If they are wrong about that, they have no defence. If they're right about that, we then move into the European dimension. If I have a San Giorgio right which is not being given an effective remedy, then one has to disapply Section 87. So we only get to the European point if I'm wrong on, well, actually either of my first 2 points, because if I don't have a common law claim, San Giorgio may require that I be given a common law claim and that the common law be moulded.
And we can't read Section 80, subsection 1, as applying to you in order to get round it.
And that's common ground.
No, quite.
So it's common ground we're not within this. It's common ground that we do not have a claim within this. We're not a person who can bring a claim within this. But it said that although we're not people within the statute had the intention of excluding any claim by us at all. And we say with respect, that is not how the statute was intended to work. It was directed at the taxpayer, it was to regulate claims of the taxpayer, and all this was doing was to say to the taxpayer, do you remember fine arts where you had a claim outside the section? That's going to disappear. This is the only way in which you can bring your claim. But it had nothing to do with us. And that is, of course, the point on which the Court of Appeal and the learned judge disagreed. Now, the learned judge, at first instance, as I say, acknowledged that the words were, the natural and ordinary meaning of the words were as we say they were. It didn't. It excluded claims outside the section only by taxpayers within the section. But he said there were purposive considerations which drew it out. And the purpose of consideration that he had is he said it would be inconceivable that Parliament could have intended that we should have a claim outside and therefore have a longer limitation period than the taxpayer within. And the Court of Appeal said in answer to that, the Court of Appeal disagreed, and in our respectful submission we're correct to disagree, because they said that presupposes that the legislature had in mind this sort of claim. Because it's only if you have this sort of claim that you can have a view as to whether you should have a longer limitation period or not.
It's a defect of the common law, isn't it, that we're inventive in developing the common law, but we then say, the fact that undermines a statutory scheme and an obvious statutory intention is irremediable.
Well, with respect, my Lord.
I mean, the whole of this arises from judicial ingenuity in inventing a new claim for mistake of law and so on.
Well, with respect, my Lord, in my respectful submission, your Lordship is looking at it through the wrong end of the telescope. What we have here is a situation in which the revenue have indubitably been unjustly enriched. They've been unjustly enriched as a result of their own unlawful conduct. The question is there anything that they can hide behind to enable them to hold on to that unjust enrichment? And I don't mean unjust enrichment in a legal sense. I mean they have been enriched in circumstances where they have unlawfully exacted tax, which they shouldn't have. One shouldn't be oversympathetic to the revenue. If there was a statute which applied to prevent my claim, then I accept I don't have a claim. But what one shouldn't be doing is to be saying, well, wouldn't it be nice, because it's unfortunate that the statute doesn't cover your claim. In my respect for submission, exactly the opposite is true. They should not be able, this isn't a situation in which we don't know the position. All the usual arguments as to why a limitation period should apply don't apply here. There's no doubt they've been unjustly enriched at our expense. As I say, if there's a limitation period which applies, I'll have to suck it up. But if there isn't, in my respectful submission, one should just accept that there isn't.
The original Euro point, which held that this should be exempt from VAT, was that based on some notion of discrimination, or was there something positive in Europe? It was simply discrimination. I never understand with discrimination why it is you necessarily expand the scope of something which was limited. Anyway, that's what that's
what they said. They said there was an exemption for, I think there were open-ended investment trust schemes, and what was the basis for discriminating against closed-ended investment trust schemes? So
it seems to enable the European legislature simply to rewrite the jurisdiction, the legislation. I mean, in a sense, you've been lucky.
Well, with respect, my Lord, again, if I can respectfully say so, your Lordship is looking at it through the wrong end of the telescope. The sixth directive, we now know, says what it says, and the UK legislature did not enact what it should have enacted. Yeah. And that is why we're in the situation where they have unlawfully claimed taxes in their possession which they do not want to give back. Yeah. As I say, if they have a defence, that's great, but we shouldn't be looking for a defence for them. Now, I ought to just deal with one more point in the context of the purpose of considerations. In the context of the purpose of considerations, your Lordship knows that Mr. Justice Henderson, at first instance, said, you can't possibly say that the legislature did not have in mind the position of the consumers, because look at section 80, subsection 3. There's a an unjust enrichment claim, and that tells you that the legislature were aware of the existence of the consumer. But with respect to the learned judge, there is the world of difference between being aware of the existence of the consumer and having in mind the possibility that the consumer might have a common law claim. That's not what they had in mind at all. They were here dealing with claims, as I say, again, following finance by a taxpayer against the revenue. Now, I'm not going to take your Lordship through authority to influence you one way or other as to what the words mean. University of Sussex, with respect, is a case in which my Lord Newberg approached this not on the basis that this was intended to be an exhaustive scheme which captured all claims. Your Lordship had regard to the words that were used and said, well, the words don't catch this claim. And that's with respect all we're saying one should be doing here. Not approaching this with a predisposition to think this was an exhaustive code. The extent of the code goes as far as the words. Now, as I say, the learned friends cite the Kintervale case about statutes always speaking. I don't have a problem with statutes always speaking. The question is, if it always said dogs, it says dogs. Well, we're cats, if I can put it that way. We're not within the meaning of that statute. Again, let me then, I think, just say this. One of my learned friends' points is to say, well, in fact, even if there wasn't an express exclusion, there could have been an implied exclusion here. With respect, that is an incoherent submission. What is my learned friend suggesting? The reality is there is an express exclusion. Is he suggesting that you should find an implied exclusion which goes beyond and is therefore inconsistent with the express exclusion? Because in my respectful submission, that is not an approach that the court is likely to take. Learned friend prays in aid in that context. He didn't mention them in his oral submission, but cases like CPAG and indeed Munro. Now, we have referred, and it's in this context that we've referred to DMG and Woolwich. One could also refer to Marsich against Thames Water. There are whole lines of cases. They break down into two types of case. There are cases where you have a statutory scheme, and CPAG, Child Protection Poverty Action Group, was one, where you have a scheme which regulates claims brought by a particular person. In that case, the Secretary of State, I think, for overpaid benefits. There is no express exclusion there. There is no express statement as to the extent of the claim. And the court says you can imply that this is intended to be an exhaustive scheme. Why? Because any claim that you would try and bring at the common law would be inconsistent with the kind of claim that the legislature is giving you here. And you can imply or infer from that, indeed necessarily infer from that, that the intention of the legislature was that this should be exhaustive and should exclude common law claims. That is CPAG. It also applies to Monroe, which was Section 33 of the Taxes Management Act, and it also applies to Marsich and Thames Water, which was a scheme about sewage. On the other hand, you have cases falling into the DMG and Woolwich line. These are cases where the person in question is not within the statute in the first place. And the question arises whether the statute was impliedly intended to be exhaustive of claims by a person who's not within the statute at all. So in DMG again, Section 33 of the Taxes Management Act, Woolwich again, Section 33 of the Taxes Management Act. And we've given your Lordship the references. I wasn't proposing to take time to go through that. But on each of those cases, what the court says is, this is not a person within the Act. Therefore, the Act can't exclude their scheme. Sorry, their claim. As opposed to Monroe, where the person was within the Taxes Management Act. And because any claim at common law by that person would be inconsistent with the statutory claim, the court says that the statutory scheme there was intended to be exhaustive of their claims. Now, we are not, as I've said, and it's common ground, within the scheme. And therefore, insofar as one wants to look at other cases for guidance as to how one should approach this, and this only arises in the context of the implication of an exhaustive scheme, which, in a sense, my learned friend puts as his primary case, in my respectful submission that it's hopeless, we fall into the analogue of DMG Woolwich claims and not into the CPAG Monroe claims, because we're not within the scheme, and therefore we do not have a claim at common law which is going to be inconsistent with the claim that the statute is going to give us. My Lord, subject to your Lordship, that's all I was going to say about issue 2. I just want to make sure I haven't left anything out. Yes. Now, can I then move on to issue 3, which is the euro
point. Yeah.
And again, just to put this into context, if I'm right about issue 1, that I have a claim at common law, and I'm right about issue 2, that it's not excluded by section 87, we do not get into the European.
Yep.
If I'm wrong about either issue 1 or issue 2, we get into the European point.
And the European point also, as I understand it, comes in relation to issue 1 and issue 2 as being relevant when we're considering the strength of that.
Exactly.
But they are freestanding
It
points
informs-
once one gets to issue 3.
Exactly.
Yep.
And why does the euro point matter? Because as your Lordships know, cases like Fleming and the like, if I have a San Giorgio right, and there is something in English law which prevents that right being effective, this court, English law, will disapply. So one either disapplies the statute, if that's why your Lordships are against me, if your Lordships are against me, or if common law doesn't give me a claim here, your Lordship has to mould the common law, just as your Lordships did, or at least as the House of Lords did, in DMG, in Sempra, where your Lordships will recall there was a bar to a common law claim because of la pintada,
Yes.
and effectively la pintada was disapplied. So the common law was moulded so that notwithstanding my claim was simply for interest, English law recognised that I could bring that claim because it had to, because European law said I had to have an effective remedy. Now, as I think I said, foreshadowed a little earlier, perhaps I should just mention, we deal with this just for your Lordship's note, written case, paragraph 65 to 79, that's core, tab 10, pages 203 to 212, and the commissioners deal with it in 2 places, paragraph 59 to 64 at tab 9, that's to deal with it in paragraphs 11 to 20, tab 11, pages 225 to 230. And that's because there is a split between how European law applies to the 75s, if I can call it that way, and how it applies to the 25s. Now, can I just identify the points of common ground in relation to the most important, in fact, most of the important points here are common ground.
Yeah.
Following Reemsma and Danfoss, although at first instance the commissioners were arguing that this was not the case,
Never mind. Yeah.
it is now accepted that the consumers, in a situation such as the present, have a San Giorgio right to repayment. They themselves have a San Giorgio right to repayment. And that's going to be important for a point we will come on to. It's also accepted that as a consequence of having a San Giorgio right to repayment, English law has to provide a remedy which will enable repayment to take place. And let's just put this into context. At this stage, we're talking about, there is no, as I say, there's no issue that they are unlawfully enriched, that they have our money. I'm not trying to do it for the purposes of English law, English unjust enrichment law. There's no question that the burden of the tax that is at law enriched them has come from us. So, European law says we have a St. George right. European law says that English law has to provide an effective remedy. What European law also says, and this is in line with a general approach that EU law takes, is that it's up to the domestic law to provide a remedy, and that European law will not interfere provided the domestic remedy is effective and, of course, equivalent, but we don't need to worry about equivalence here.
Okay.
As long as there's an effective remedy, that's okay. And what does that mean? It means that your right, your ability to vindicate your St. Georgia right, that's to say to claim back what you have paid and the amounts by which the state has been unlawfully enriched, is not made impossible or too difficult. And in that context, it is also clear from, and this is common ground, Riemsma and Danfoss, that it's okay to have a legal system which blocks a direct claim against the state, and for this to be dealt with by a statutory mechanism which only allows the taxpayer to bring claims against the revenue, provided that satisfies the principle of effectiveness. That is to say, provided that does not mean that the ability of the consumer to get repayment is made impossible.
Yeah.
What is also common ground is that in the case of the 75s, it is impossible for the consumers. Sorry, in the case of the 75s, at least for the dead period, because we've received back all the others, it is in fact impossible for the consumers to be repaid the amounts by which the state has unlawfully enriched itself. And the question then is that okay? Does that satisfy the principle of effectiveness? Because if, having regard to the way the statutory scheme works, it is in fact impossible, as is common ground, that the consumers recover the 75s for the dead period, then EU law will require that, regardless of Section 87, regardless of what the common law says currently, the consumers be given a direct claim against the revenue for the amounts which they have not recovered. That is clear. But what do the revenue say? They accept, as I say, that we have a St. Georgia right. They accept that it has to be effective. They accept that it is impossible for us to recover certain amounts. But they say, notwithstanding that, we should not have, you should not find that the doctrine of the principle of effectiveness is engaged here. And they say that effectively, as we understand it, for three different reasons. And if I can identify the reasons first and then deal with them. The first reason they identify is to say that the reason you haven't been able to vindicate your St. Georgia right in relation to the period from 1996 to 2001 is because there is a defence to your claim as a matter of English law. So they say your claim against the managers fails on its merits. That's it. I'll come back to that in a moment. In my respectful submission, that's hopeless. The second point that they make, and maybe that there are 2 points here as opposed to 3, is they say that the reason you are not recovering this money is by virtue of a limitation provision in Section 80, subparagraph 4, which they say is compliant with EU law. And then the third reason, if I can put it as a third reason, it's closely related to the second because it goes to the limitation period. What they effectively say is, if you don't like that argument, how about doing what the learned judge at first instance did, which is to say, yes, I have to disapply Section 84, Section 87, but what I'm going to do, notwithstanding that disapplication, is to apply to you the limitation provision in that statute which I've now disapplied, even though everyone accepts that it doesn't apply to me. Okay, application by analogy, I think, is the way the learned judge at first instance put it. Now, in our respectful submission, there is none of those points assist. Can I deal with the first point? And I will, to the least extent possible, take your lordships to Danfoss and Reemsma, but I'm going to, because you've seen them, I think, most of it, but I still have a fair amount of it. So far as concerns the first point, the suggestion, as I say, is that because your claim fails by virtue of a defence to the claim which exists in English law, the doctrine of effectiveness is not engaged, and you should, in a sense, just lump it. You may not have been able to vindicate your rights, but too bad. Now, as we've said in our written case, one could test the sense of that proposition in the following way. If one assumes that rather than the case failing by virtue of a defence to the case, it failed because we couldn't satisfy a critical element of the cause of action. For example, English law did not recognise a claim against the manager for unjust enrichment at all. Doesn't really matter why. Could it possibly be said that notwithstanding that, the doctrine, the principle of effectiveness was not engaged? In my respectful submission, the answer to that is plainly no. And we know that from Huscht, Metallgesellschaft and DMG. Your lordships will recall, I mentioned it a few moments ago, what this European Court of Justice had to deal with in DMG. If I can take a step back. DMG was a case about advanced corporation tax, as some of your lordships will recall, and scarred on some of our memories. Advanced corporation tax, which is to say that tax was paid before it was due. By the time the matter came to court, the tax which was due was due, but it had been paid early. The claimants in DMG said, well, we may have been liable for the tax, but we didn't have to pay it at the time that we did. Therefore, we've lost the time value of money. We've lost interest on the money. We want a claim for interest. As a matter of English law as it stood at the time, as a result of cases like La Pintada, the English common law did not recognise a claim purely for interest. You could only claim interest on the back of a claim for repayment of a debt, and then you could claim the interest due on that debt. What you could not do was issue proceedings simply to recover.
There was no freestanding claim for it.
No freestanding claim. I'm grateful, my lord. When this went to the European Court of Justice in Metallgesellschaft and Huscht, the European Court of Justice said, you have to disapply that. I don't know whether it was a defence or an absence of a cause of action or whatever. You have to disapply it because it interferes with the principle of effectiveness. You have to provide an effective remedy.
Yeah.
Now one asks oneself, I don't even know what this is, but if the La Pintada point arose as a defence rather than as part of the cause of action, would
The what point? Right?
La Pintada.
Oh, La Pintada, yes, right.
If the way it comes before the court is that someone has to plead it as a defence rather than to saying you don't have a cause of action in the first place, would the decision of the European Court of Justice in Metallgesellschaft and would the decision of this court, of the House of Lords in DMG, have been different? In our respectful submission, plainly no. It doesn't really matter whether, as a matter of the way in which our law develops, something arises by virtue of having to plead it as a defence rather than as an element.
I see, if you're concerned with effectiveness.
Exactly. Why should it matter?
Understand.
And what we're dealing with here, after all, in the context of that, is a defence which, as is reflected in Section 83, is almost always getting, sorry, not in Section 80, but as a consequence.
What is the defence which you say that they rely on?
Change of position.
Change of position.
And that's common ground. It's common ground that the reason we cannot succeed is change of position. Now, does it matter that the way English law works is to say you must establish let's put this differently. Lord Steyn in Bank Financier identifies 4 questions which arise. If he had identified question 4, which is currently, is there a defence? If there had been, and there must not be a change of position as part of the cause of action, could it possibly be said that the principle of effectiveness is not engaged? I respect for submission, no. But that's effectively, they may be going further. They may be saying that if English law does not provide a cause of action here, that's okay. Or if English law provides a cause of action which we simply can't bring ourselves into, that's okay. But in our respect for submission, that is hopeless.
Well, where is the change of defence position put in the appellant's case, for example?
Well, let me show your lordship change of position. I think it's common ground. If your lordship looks at when we applied for permission to appeal, just need to find para 61 at page 159.
Yep.
Your Lordship looks about 7 lines down, I'm grateful.
Page
Page 159.
159.
159, thank you so much.
Although the ITCs have no need to assert it, the ITCs did have a claim under domestic law against the managers. That domestic law claim did not entitle the ITCs to recover from the managers paid within the dead period because the managers would have a defence of change of position in respect of those monies as a result of having paid them over to HMRC. We're talking there about, I think, the 100, not just the 75s.
So, I mean, if there was a... And your, what is the time limit? When's the starting point of any time limit you have for a claim against the revenue? It's the 6-year one, is it?
It's 6 years after the date of discovery of the mistake. It's section 32. It's section 5 plus section 32(1)(c).
Right.
Yeah.
My Lords, they rely in this regard on something which I think was said by the Advocate General in Reemsma, where the Advocate General says it has to be unrelated to the merits of the claim. If it fails for reasons unrelated to the merits of the claim, then EU law will step in and give you a direct claim. One can, and what we say is that the unrelated to the merits of the claim is unrelated to the merits of the claim as to whether someone has got money as a result of the unlawful exaction of tax, not the merits of the, not that there is a defence in the way in which English law deals with this, which means you will never be able to recover your unpaid tax. In our respectful submission, that would be an astonishing position if that's what the Advocate General had in mind. That is, the statement which she makes, on which my own friends rely, the Lordship will have noted, is not repeated in the decisions of either court, either in Reemsma or in Danfoss. So they're relying on something which is said by the Advocate General. In our respectful submission, they're completely misconstruing it, but in any event, it's not something that one finds in the court's decision. And I say they're completely misconstruing it, as I say, because it is irrational to think that it would be not okay for English law not to provide a cause of action, but it is okay for English law to provide a cause of action subject to a defence which, in a sense, is almost bound to succeed. And one can test it in a different position, in a different way. The premise, if one looks at Danfoss and Reemsma, of saying, in fact, the case which they keep identifying, where they say you should have a direct claim, is a situation in which the taxpayer goes insolvent. Now, what that presupposes is that you would have a successful claim against the taxpayer, that you would be able to vindicate your money against the taxpayer. But despite that, notwithstanding that, he's gone insolvent and you can't claim because of that. And even then, because he goes insolvent, you have a claim, a direct claim, against the commissioners. We're dealing with a situation in which English law wouldn't even give us a successful claim against the manager. And it's being said that in that situation, it's okay. I mean, it's not even okay if English law did give us a proper claim, if we still couldn't recover because the manager went insolvent. So in our respectful submission, for that reason also, this first objection with respect makes no sense at all. We then get to...
Just to test that, if I may, do you accept that European law would allow a member state to impose a time limit on
Absolutely.
the consumer pursuing a Danfoss or Reemsma claim?
Absolutely accept that.
Yes, but if that is the case, what is the mischief of English law by virtue of a change of position defence bringing in the time limit which the taxpayer the next down the chain faces?
The Lordship put to me whether I'd accept that, would I accept that European law would accept a time limit being imposed on a claim by the consumer, and I said I absolutely did. But you don't have a time limit being imposed on the consumer here. That's a time limit being imposed on the manager.
Time limit being imposed on?
On the manager.
On the manager.
There is no time limit in that statute which is imposed on us at all. We're not in the statute, section 80, subsection 4. It is common ground, is not understood. In a sense, this brings us on to the next point. But in our respect for submission, it's a thoroughly bad point that my learned friends take, because they seek to apply to us a time limit which they accept as a matter of the legislation does not apply to us. And they seek to do so simply by continually saying European law accepts that you can stop a claim succeeding by time limit as long as you give as long as it's reasonable and you give advance notice. That is not a proposition with which we take any.
You say there's no need to search around desperately for a time limit anyway, because you've got 32(1)(c).
We've got one.
You understand?
I will come to that, because that in a sense is where we get to the third one. But the second point, since we're on it, I don't think I have anything more to say.
I mean, it simply arises, does it, then, because of the discrepancy in the time limits between the Limitation Act and 3 years?
Yep.
You accept in answer to Lord Hodge that if they'd been back-to-back, both 3 years, you would be entirely legitimately caught and wouldn't have a St Giorgio claim.
Exactly.
But you say the error is in saying because 3 years in section 80 would have been a perfectly good time limit, doesn't mean it is.
To us.
No.
Because it doesn't apply to us.
I understand.
Yeah.
Understand.
And again, my lords, your lordship, again, I do want to keep saying this. I'll say it once more and I won't ever say it again, I promise. One shouldn't be casting around too far to see if we can find a defence for the commissioners. If they have a defence, I accept that. But we are not behaving mischievously here. There is no doubt that they have been enriched at our expense in a real, substantial way. The only issue is there anything they can hide?
We have that.
So, I've dealt with the first point, which is there's a defence as a matter of English law. So far as concerns the second point, there's nothing wrong with this time limit, it's EU law compliant. It's true that it's EU law compliant, but with respect, what has that got to do with us?
Right.
It may be the reason why when we claim against the manager is able to say, I have a change of position defence. But the fact of the matter is, he has a change of position defence, which means that the principle of effectiveness, notwithstanding the principle of effectiveness, we're being denied our San Giorgio right to recovery.
But that assumes that it is a matter of European law that you're in some way entitled to 6 years.
No, it doesn't assume anything at all. It assumes
claim.
we're entitled, subject to whatever limitation periods are reasonable and are apply, to be repaid what we have had taken from us.
Either there's no bar on you, as a matter of English law under the VAT legislation, or there is an absolute bar under Section 80, subsection 7.
Exactly.
If there's no bar, then you look at the Limitation Act, because Section 80 doesn't apply. If there is a Section 80, subsection 7 bar, that means self-evidently you've never had a claim that you can bring, and therefore that has to be disapplied on the grounds of effectiveness.
Exactly.
And that brings you back to Section 32(1)(c) in each case.
And that really takes us to the third of the ways in which they put it, which is really related to the second, which is the learned judge's way of putting it. Which is to say, this is a rum state of affairs, that although the manager would have been subject to a 3-year limitation period, you chaps are subject to Section 32(1)(c), and you get much more than the manager would have got. And effectively, it's not clear what he does. There are two possibilities. He either says, I apply Section 84 by analogy, which I think is what he ultimately does say, or he may be saying, it is possible to disapply Section 87 subject to Section 80 subparagraph 4, by the limitation period. But with respect, there are serious problems, insurmountable problems with either way of putting the case. Can I just deal with I'm going to disapply, but subject to Section 80, subject to Section 84 in any event? And there are 3 points that we make in relation to 3 points that we make in relation to that. Perhaps I should just show your lordship again where the learned judge dealt with this. So tab 12.6, paragraph 141. It begins at page 352.
Yes.
I just wonder, my lord, if your lordships are happy to deal with this now, I will deal with it now,
Yes.
but I'm making decent progress.
Is this a hint that we could conveniently adjourn now?
It is. Subject, rather than taking this point, perhaps I'll come back to this point because there are a few points to make together. The one thing I have repeatedly repeated and not shown your lordship is paragraph 69 of the AG, the Advocate General in Danfoss. And can I just show you?
Yep, that will be fine.
Your
Come back
lordship,
to
and then if we subject to your lordship.
Fine.
So Danfoss is a tab bundle 2, tab 14, is it? Tab 14. Paragraph 69 of the Advocate General is page 753. I do apologise. Just wanted to show your lordship this paragraph, which in a sense goes to the earlier points I was dealing with under this head. She says this. In the main proceedings, however, it is ultimately for the referring court to consider whether the principle of effectiveness requires that a direct claim for repayment against the state should be considered. The Danish government, commenting on the legal situation in Denmark, has argued that the final consumer does not have the right to make a direct claim for repayment against the state. Danfoss and Sauer Danfoss, on the other hand, and they're the taxpayers, have argued that as the charge was passed on, the taxable person too has no claim for repayment against the state, and therefore the final consumer for his part has no claim for repayment against the taxable person. If both arguments are correct and the final consumer cannot consequently claim repayment of the charge either directly or indirectly, the exercise of their rights by the applicants in the main proceeding would be made excessively difficult, for reasons she goes on to explain. So in other words, she contemplates a situation in which you can't sue the taxable person because he's passed it on, and this postulates a situation in which you can't sue the state either.
Yes.
And as we've seen, passing on is perfectly legitimate part of, your lordship saw that from St. Giorgio, it's been repeated in cases such as Lady and Kid. So here you have an entirely EU law compliant defence, which operates to mean you can't claim against the taxable person. The fact that it's EU law compliant is an irrelevance. The Advocate General makes it clear that in her view, this is excessively difficult and something needs to be done. Now, subject to your lordship, if your lordships are content, I'm happy to come back to you.
If we're doing well in terms of time, I think that seems sensible. Thank you very much indeed. Very well, we'll resume again then at 10:30 tomorrow.
It's 11.
Is it 11?
11.
We'll resume again at 11 tomorrow. Thank you very much. Court's now adjourned.